Hello and welcome to Doughty Street's webinar responding to the landmark ICJ advisory opinion on climate change, which was handed down last week. My name's Harj Narulla. I'm a barrister specialising in climate law and litigation at Doughty Street Chambers, and I represented the Solomon Islands in this case. Today I'll be chairing this session alongside my two colleagues, Nicolas Angelet and Jennifer Robinson, and we're going to be speaking about what this case means, why it's so significant, and why it's had so much coverage over the last week or so. So I'll just briefly introduce Nicolas and Jen. So Nicolas is a professor of public international law at the University of Ghent, and he represented the DRC in the proceedings and made oral submissions at The Hague in December. And Jen is a leading international human rights lawyer who represented both Vanuatu and the Marshall Islands in the proceedings. So we're just going to make some short presentations for about 10 minutes or so, and then we'll allow for about 20 minutes of questions at the end of this session. So I'll hand over to Jen, who'll be speaking about the key findings of the court in relation to question A. Go for it, Jen.
Thanks, Harj, and good afternoon, everyone. What an exciting decision. I wanted to address 3 points today. First, a bit about process and how these unprecedented proceedings came about and how I think that process has affected the outcome and such a strong response from the court. Second, an outline of the key findings, at least from Vanuatu and the Pacific Small Island Developing States perspective. What I think are the most significant findings or key ones for us for the Pacific, and Harj and Nicola are going to expand on a couple of those points in more detail than I will, and just a few words about the implications and the impact of this remarkable decision. So in terms of process, I acted for Vanuatu and have been working with Vanuatu for 5 years in getting these proceedings to secure this outcome. Vanuatu is a very small Pacific Island state, and I in fact acted for Vanuatu in their first appearance in the ICJ in the Chagos proceedings in 2018. Which, of course, as we all know, led to the hand back of the territory to Mauritius by the United Kingdom. And I've been working with Counsel and this team. So this is their second appearance in the ICJ, and what an appearance to make in terms of the impact this tiny little island state has achieved. So as you know, this started with law students in the Pacific. Of course, we discussed academically the prospect of advisory opinion proceedings in respect of climate change, but I think the general consensus was it would be politically impossible to achieve that. But it was a group of students in the Pacific at the University of South Pacific who made this demand of Vanuatu and of states in the Pacific. And I'm proud to say that it was Vanuatu who picked up that call and ran with it. So it was a huge task to build consensus, not just among states, but in the civic space. We got a UN General Assembly opinion which was adopted for the first time in the history of the UN by consensus to refer the matter to the ICJ, and also the highest participation rate of governments ever in any proceedings, with 91 governments appearing. And of course, we got a unanimous advisory opinion with a range of separate opinions and declarations from judges, which not only is the unanimous decision so strong in terms of from Vanuatu's perspective and the Pacific's perspective in adopting the submissions that we put forward on all of the key legal points that we raised, but also because so many of the judges made separate declarations and opinions that urge, in fact, say the court should have gone further in some ways and clarifying and pushing the direction of the law towards much more stringent obligations for states. So I think it's a remarkable achievement for Vanuatu. But I just wanted to say a few words about how I think that the participation of states impacted upon the decision. So in the Chagos proceedings, President Yusuf, as he was then, spoke about the breadth of state participation in those proceedings and how important it was to see the diversity of state representation and council representation before the court. And I do think it made a difference in the oral proceedings, watching government after government stand up and speak about the horrific adverse effects of climate change on their country, on their economy, on their cultural heritage, on the environment. And I think that really would have given the court the impetus for the decision that we've just received. What was also, I think, two other factors that were key in the court's decision was the lived experience of affected climate communities being brought to the court. And that was very much a focus of our legal team led by an Indigenous Pacific law firm, Julian Argon and Blue Ocean Law, in making sure that these lived experiences were really front and center in the way that the case was presented, and also the role of climate science. And I really want to acknowledge the role of the South Pacific community in helping small island developing states, particularly in the case of the SPC in the Pacific, in building this scientific knowledge base and the modelling that was required to be able to show the court the very real implications of, for example, sea level rise. And as counsel working with Marshall Islands, I observed the court's reaction to the presentation of the Marshall Islands showing the sea level rise modelling and what it would mean for the Marshalls, even at a 1.5 degrees temperature increase. So I think all of these factors, the level of state participation, the unanimous consensus in getting it to the court, and the strength of the evidence that was put before it played a part in the strong decision that we received. So looking at some of the key findings, and I'm just going to give you some bullet points because we just don't have the time in 12 minutes to articulate them all. But of course, the most important is that all states have binding customary law, international obligations to take action to protect the climate system and to prevent climate change. The court was very clear about the 1.5 degrees being a binding obligation. We know that states aren't setting their NDCs at that target, and the court made clear that they need to be. There was also the recognition, which was very important for countries like Marshall Islands and Vanuatu, that 1.5 degrees, while that is the scientific consensus of what we're all aiming towards, is not safe for many countries. And that was clear in the scientific evidence, as I mentioned, as referenced by the Marshall Islands and presented by the Marshall Islands and other countries. It's really important that in making that finding, the court rejected the arguments of the US, Australia, Saudi Arabia, and other big emitting states that climate change treaties were lex specialis. The court unanimously rejected that proposition. And the court unanimously made clear that good faith compliance with obligations under the climate treaties can, but does not necessarily mean compliance with the customary law obligations on the duty to prevent. And I think that is a really important finding. And I also think it's important to have a look at the joint declaration from Judges Brandt, Charlesworth, Cleveland, and Orescu, who set out in more detail and clarify in a way the court's findings, making clear that that has to be read in light of the finding on lex specialis, and that while these treaties aren't aiming to codify or to amend customary international law, but constitute instead a gradual attempt to develop scientific rules on climate mitigation, adaptation, and climate law more generally. And I think there's some really interesting aspects of the way the court looked at the climate treaties and those obligations and how they need to be determined. And I think a key one, particularly for Pacific Island states, is that states do not have discretion or a complete discretion in determining their NDCs, that they have to take action consistent in determining those NDCs in compliance with customary international law, which is a strict due diligence obligation, taking into account historical emissions, and that they must consistently tighten these agreements. So as we're looking at countries like Australia about to set their NDCs, this decision will impact those current states' current assessments of their NDCs and will of course have an impact in the negotiation rooms. I want to make clear too that I had a great conversation with Christiana Figueres, the former head of COP, and one of the things that she said most clearly was that how useful this decision will be in driving climate negotiations and for negotiators to pull out this normative decision in pushing for more ambitious state action. I think also too, it's important to some of the findings around what might constitute a violation of that duty, including fossil fuel subsidies, continuing to approve fossil fuel projects, and that states need to consider these obligations. So those actions in respect to fossil fuels could constitute a violation of customary law obligations. And the clear statements made by the court went further than I expected them to go. And you can see, I think the Bandara and Cleveland Joint Declaration is an interesting one to look at in terms of what that actually might look like and those obligations might look like in practice. A really important thing for the Pacific was these questions around sea level rise and statehood and the impact of sea level rise on boundaries and statehood. And of course, that we were very pleased to see the findings of the court around the fact that sea level rise will not necessarily affect statehood, and nor do states have obligations to update their maritime borders. This was a massive priority for Pacific Island states, which will have a significant impact on ongoing practical negotiations in the region, and was considered a huge win for the Pacific. Though it's worth looking, I think, at Orescu's separate opinion in particular about how the court could have done better on that. State responsibility is a big one, and Nicola is going to speak more closely to that and in more detail to that. But of course, we were thrilled that the court agreed with us in our submissions that the normal rules of state responsibility apply in the context of climate change, rejecting arguments like those made of Australia that it's all too difficult to find attribution and causation. As the court said, it's scientifically possible to do so, and that means that while of course they're not making any specific determinations in reference to any particular state, that it made clear that those rules apply and that the usual remedies, including cessation, restitution, and reparations, apply, and even made reference to what restitution obligations might look like in practice. Finally, from a human rights point of view, I wanted to reference a few key important developments. Of course, we've had significant case law developments and decisions from the Inter-American and European courts. But of course, this is the peak global international court. And I think it will make, as Judge Charlesworth notes, a significant procedural contribution if it doesn't affect necessarily states' mitigation and adaptation obligations because of the customary international law findings, certainly from a procedural point of view in terms of broadening access to dispute resolution procedures and standing for individual rights holders. The key one that people are talking about, obviously, is the right to a clean and healthy environment, and the court found that that is a right under international law necessary for the protection of all human rights. But what the court didn't do is make clear what the status of that right is, and I think it's worth looking at, Orescu's separate opinion on that failure and what it means, because the judge takes time to set out from a customary international law point of view why that right does exist as a matter of customary international law. A really important key finding in the human rights context was also obviously about non-refoulement in the context of climate change. Vanuatu, the Marshall Islands, Solomons as Pacific Island states all raised this as a concern about the failure of the Refugee Convention to address climate change, and the court recognised, of course, that non-refoulement does apply in that context. One of the shortcomings, I think, of the decision was a lack of exposition on the right to self-determination. There could have been, I think, a lot of focus on that, and there was a lot of that from Vanuatu, Melanesian Spearhead Group, and other Pacific Island states. So I think we could have seen more on that, but I recommend the separate opinion of Justice Sibuntende on the question of self-determination, which is an interesting read. Just finally, to wrap up, this obviously is going to have massive implications. It already has. We're seeing widespread coverage of it globally. We know this is going to make a difference in terms of domestic, regional, and international litigation going forward, and that certain countries are considering what potential future interstate and other claims might be possible off the back of this decision. So from the perspective of Vanuatu and the Pacific, this is a huge win for climate-affected communities, a huge win for the region and for climate vulnerable states and communities around the world, but also for young people. And one of the most inspiring things I think about this case is that it started with a group of students in the Pacific. I was sitting in the General Assembly. One of the best parts of being there that day the resolution was passed was watching government after government representatives stand up and thank the youth for demanding this action from states. And I've certainly never seen that in the context of international law, where a social movement has been so recognised in this process. So when the UN Secretary General said that this is a victory for the planet, for climate justice, and for the power of young people to change the world, I think he's right. So it's exciting from that point of view what those students have achieved. And with that, I will hand over to Harj.
Great. Thank you so much, Jen. So many wonderful and really significant points in there. And I think we were in the same slot as Marshalls and Cook Islands in presenting our submissions in December, and it was really powerful seeing the impact of the visual presentation which the representatives of Marshalls did, just showing just physically maps sea level rise, and you could really see the judges responding to it. So I think that's if anyone hasn't seen that, it's a great thing to go back and watch. So thanks so much, Jen. Nicola, I'll hand over to you to speak to questions of state responsibility and reparations.
Thank you, Harj. Well, I think as a start, state responsibility plays a double role in these advisory proceedings. First, of course, it is important from the viewpoint of restorative justice for the victims of climate change to obtain compensation for losses already sustained. But also second, as importantly, in my view, state responsibility and the statements by the ICJ on this issue play a preventive role. State responsibility must function as a sort of Damocles to prevent future wrongdoing. It must contribute to effective respect for primary rules set out in the opinion. So that is the dual role, I think, of state responsibility in the context of climate change and in the context of the opinion. So let us consider the preventive role first. Obviously, this is the least demanding role because we do not need the sword of Damocles to fall. We just need it to hang there convincingly and to communicate a credible risk. In my view, with the court's answer to question B, the sword indeed hangs there very convincingly. And that is for a number of reasons. First, as Jen already pointed out, the court gave the law of state responsibility the place it deserved in the advisory opinion. Some states argued before the court that liability for climate change was subject to a lex specialis, such as the loss and damages mechanism of the UNFCCC, and the court rejected this view. Therefore, states' action and inaction with respect to climate change is subject to the law of state responsibility in general international law. Along the same vein, throughout its answer to question B, the court systematically rejects arguments to the effect that the law of state responsibility cannot effectively apply to climate change. For example, the court notes that some participants submitted that it is difficult to invoke responsibility in the context of climate change, given that the wrongful conduct, as we know, is cumulative in nature, involving different states over a period of time, involving a plurality of states that cause injury to a plurality of injured states. But the court answers that objection and stating that the rules on state responsibility are capable of addressing situations where damage is caused by multiple states engaged in wrongful conduct. Likewise, on the intricate question of causation, the court observes that some argue that causation is impossible to establish due to the diffuse nature of climate change, but then answers that the standard of a sufficiently direct and certain causal nexus between an alleged wrongful action or omission and the alleged damage is flexible enough to address the challenges arising in respect of the phenomenon of climate change, etc. So this is a first important aspect. This line of reasoning puts an end to the long-term denial, not denial of climate change, but a denial of responsibility. States cannot argue any further. They cannot believe any further that they can escape liability for climate change. So this is the end of the feeling of impunity, I would say. And from this perspective, the advisory opinion certainly allows the law of state responsibility to play its preventive role. And I think this had been caught up very well by the media, by the way. there was a lot of insistence on the risk of further climate litigation. So that's one point. But the question then is, does the opinion do more than that? Does it also contribute to effective restorative justice for the losses already sustained? At first sight, I would say, the very passages of the opinion which I mentioned to illustrate the opinion's contribution to the preventive role of the law of responsibility also evidence the difficulties that await states seeking effective redress. That is because a lot seems to depend, when reading the court's reasoning on question B, a lot seems to depend on the circumstances of each and any given case. With respect to the multiple co-authors issue, the court notes that, and I quote, factual questions arising in the context of attribution and apportionment of responsibility are to be resolved on a case-by-case basis. With respect to causation, the court observes, likewise, that the causal link must be established in each case through an in concreto assessment while taking into account the elements outlined by the court. So all this is very circumstantial, and therefore one may wonder, it does convey a threat of possible litigation, but does it convey any promise or even a glimpse of a promise of effective compensation? Or would it rather open the way to, shall I say, simulacres of justice, with courts and tribunals less righteous than the ICJ, confirming the applicable principles before finding time and again that there is no basis for reparation in the specific circumstances of the case? I think that risk exists, but I also believe that truly the court's opinion does clarify in general terms a number of very important issues that can lead to effective restorative justice. Let me mention the two main points in my view. First, with respect to the issue of multiple responsible states, the fundamental legal question and the fundamental practical question is whether each member of a group of tortfeasors can be allowed to hide behind the group and argue that its own personal contribution to the wrongful act cannot be ascertained. This is a well-known legal issue. Now, the court expressly rejects this line of defense at paragraphs 430 and 431 of its opinion. And let me quote 431, which I think from the viewpoint of state responsibility is probably the most important passage of the answer to question B. Therefore, in the climate change context, the court reasons, each injured state may separately invoke the responsibility of every state which has committed an internationally wrongful act resulting in damage to the climate system and other parts of the environment. And where several states are responsible for the same internationally wrongful act, the responsibility of each state may be invoked in relation to that act. Now, this seems perhaps self-evident, but in truth, it is the last sentence is copy-paste from Article 47(1) of the ILC Articles on State Responsibility, and it consecrates that no member of a group of tortfeasors can hide behind the others to avoid its being held responsible. So this is extremely important from a practical perspective. But then, of course, the last point is the question remains whether the individual tortfeasor then can argue that he may well be responsible, but it is impossible to determine the part of the damage that he himself caused, and therefore it is impossible to determine what amount of compensation the individual tortfeasor should pay. Now, that is also a delicate issue, which the court again addresses, this time at paragraph 454. And again, I quote, "Where there is uncertainty with respect to the exact extent of the damage caused, compensation in the form of a global sum within the range of possibilities indicated by the evidence and taking into account equitable considerations may be awarded on an exceptional basis." So this is a principle of compensation in the form of a global sum, which may apply on an exceptional basis, which is never reassuring. But then the court affirms categorically immediately thereafter, in the climate change context, reparations in the form of compensation may be difficult to calculate, as there is usually a degree of uncertainty with respect to the exact extent of the damage caused. So, in other words, where climate change is concerned, the exceptional basis is there, and compensation there will be. So, from my perspective, also on the second, more demanding aspect of the law of state responsibility and the court's pronunciation in that respect, the opinion identifies a very clear road to individual responsibility for states and to effective compensation. Thank you.
Thank you so much, Nicola. I think that's fascinating. I've got a bunch of questions for you, and I'm sure the listeners do as well. Just a reminder to everyone who is watching that we have a Q&A box down the bottom where you can put in questions, which we will come to and address later on in the session. Okay, so I'm going to try to quickly run through a number of issues that I think are of particular significance, some of which Jen and Nicola have already touched on, and others that they haven't addressed. So I'll speak about statehood, maritime boundaries, how the court has interpreted CBDRRC, so the common but differentiated responsibilities principle, the issue of non-refoulement, and if I have time, non-state actors as well, so fossil fuel companies. So the first issue I want to speak about is one that Jen's already mentioned, which is the question of statehood, which was subject to, interestingly, quite divergent views by different states in terms of whether or not submissions should be made on this topic in the first place. So the reason for that is that the International Law Commission has had an expert legal group looking at the question of statehood in the context of climate change, functioning since 2018. And so there was a view that that parallel and authoritative process should be one which should be left alone, because there was an anticipation that there'd be a favourable outcome, and that the court shouldn't be pushed to express a view about this question, this kind of fundamental and existential question of statehood. Happily, enough states ignored that advice and made submissions on it. Pretty much all of the small island developing states that are under serious threat of complete inundation from sea level rise or have lost multiple islands, which was the case. My clients, they'd lost 5 of their islands already and already had 6% of their population internally displaced. We and many others made submissions on this point and made arguments that were in line with the findings of the ILC, which were helpfully handed down in June 2025. And the ILC and now the ICJ have both found that where on the question of statehood, that where a state has already established its statehood, the disappearance of one of its constituent elements would not necessarily entail the loss of the statehood. So not as completely emphatic as it could be, but essentially getting us, I think, 9/10 of the way there in terms of a definitive declaration on this question of statehood. Obviously, there are a range of different elements that go into the question of what it means to have statehood. Those are understood generally as the Montevideo Convention criteria, and they refer to things like having a permanent population, defined territory, a government, and the capacity to enter into relations with other states. So that's a particularly significant win for, in particular, states like Tuvalu, Marshall Islands, and Maldives that are looking at complete inundation at some point in this century or next century. So a related question to that is the second point I want to come on to, which is the issue of maritime entitlements. So this is one of the big issues around the law of the sea and the UN Convention on the Law of the Sea, which fundamentally governs this area. And the question was, what happens in the context of sea level rise, either complete inundation where you've got a loss of statehood, or where the boundaries of your coastline are fundamentally changing. And that's relevant because it creates this question of what is the baseline for your maritime entitlements, which are measured according to the coastline that you have in your territory. And helpfully, again, the ICJ ruled in a progressive manner, and they said that there isn't a requirement once you have already established your existing baselines under the UN Convention. There isn't a requirement to change those in the context of physical changes to your defined territory as a result of sea level rise. So that's a huge win for small island states or big ocean states, which rely in terms of their economies, their cultures, on their maritime entitlements. And thinking forward to the context in which you have states that have been completely inundated, so they don't have a defined territory in which they are able to have a permanent population. Think about the sources of revenues and income for those sorts of states. It's going to come from things like fishing, tourism, diving, and so on. So again, this is a very important and existential question for small states in particular, but also for all states, because it creates an important plank of legal certainty on this issue of that's connected to sea level rise. Okay, so the third issue I wanted to come on to is the question of how CBDR has been interpreted by the court. And I think this is one of the most consequential aspects, actually, of the decision, which maybe hasn't been covered a lot in the reporting thus far. But one of the kind of the key questions in the climate space is which countries are classified as developed and developing under the UNFCCC framework. So when the UNFCCC was passed in 1992, it created a systematic set of categories in which they classified different types of states into different categories. And they classified, importantly, developed states, the most developed states, as Annex 1 states, and other states in different annexes. This approach has been departed from in the Paris Agreement, where they didn't retain the annex system, and it opened a question as to which states fall within which categories of developed or developing states. And this is particularly important when you think about large emitters like China, India, and Brazil, which 30 or 40 years ago had a very different emissions profile and status of development than they do today. So China, India, Brazil, those sorts of states maintain in the climate negotiation context, and again before the ICJ in these proceedings, that they are developing states, and therefore the different sets of obligations that are created under the Paris Agreement, which create more stringent and greater obligations for developed states to help developing states. The argument of those large emitters that they didn't have any of those more onerous obligations. So interestingly, and this is one of the arguments that we put in our submission, which follows one of the leading interpretations of the Paris Agreement that's set out by one of my colleagues at Oxford, Lavanya Rajamani, where she interprets the wording in the Paris Agreement of CBDR to allow for room for movement between these two categories. So that comes from how the text changed in the Paris Agreement. So in the Paris Agreement, the wording is common but differentiated responsibilities and respective capabilities, which was in the previous treaties, but in light of different national circumstances. And this was an argument that we made and Lavanya has made, which the court picked up. And the idea is that that creates a dynamic standard, which, as the court said in this case, creates a picture where it's not static. You don't have simply one category for developed states and that persists forevermore, but depending on changes in national circumstances, so an increase in emissions or an increase in your economic capability, you can graduate into developed status, or equally move from developed status into developing status. So what this sets up is a fascinating set of questions for both the COP negotiations and for future interstate litigation. It'll be really interesting to see what China, India, and Brazil say when they come to COP. They continue to position themselves as developing nations. I imagine they will. But now other states have a legal argument and a legal basis to say your national circumstances have changed, and therefore you have more stringent or more onerous obligations when it comes to providing things like technology transfer, climate finance, and capacity building, and so on. And looking further down the road to interstate litigation, we could be seeing a world in which you have more vulnerable states to climate change, maybe small island developing states, bringing cases against some of these emitters like China, India, and Brazil. Okay, I'll just come on to quickly the point of non-refoulement, which again, Jen has already addressed. One of the biggest impacts of climate change, the UNFCCC has actually said that the biggest impact of climate change is displacement because of the hundreds of millions of people that are due to be both internally displaced and displaced across borders due to climate change in this century. That was one of the issues which was not really a focus of many state submissions in these proceedings. It was something that the Solomons focused on quite a lot, and I think we were the only state to make written submissions on this particular point in relation to non-refoulement. And the argument was essentially that when people are displaced across borders, which is a relatively small percentage of all of the people who are going to be displaced due to climate change, we said that the human rights principle of non-refoulement applies, and that states have an obligation to provide protection to those individuals and evaluate whether or not they face threats to their to the right to life if they are returned to their originating country. And that's what the ICJ found, and they importantly reaffirmed a UN Human Rights Committee decision, Te Tioto and New Zealand, which was a landmark decision at the time, which had commentary on this point in particular. So that was, I think, quite a surprising development for the court to go into that issue. They didn't speak about the Refugee Convention and its definition, but that helpfully is something that the Inter-American Court of Human Rights in its advisory opinion did refer to. So we've seen development from other international courts addressing that question. Okay, I think in the interest of time and seeing quite a few questions coming through into the chat, I'll leave my remarks there, and maybe we can pick up on the question of corporate liability and fossil fuels in response to some of these questions. So I'm just going to take these in order of which they've been received. So the first I'm seeing is, in a case where states' boundaries blur, i.e. tort legal limits within allowable range individually, but the total is harming, how to proceed further from the harm state's perspective to defend their rights. Nicolas, should I throw that one to you to address, please? If you have a view, and I think you're on mute.
Sorry, I was muted. It's really a difficult one. Do you have any idea, Harj or Jen?
Yes, so I think this is a question about essentially my understanding of this question. If the boundaries is about potentially jurisdiction, I think this is a question basically about target selection and who you can validly bring a case against. And so I think, Nicolas, your points earlier sort of picked up on this, which is that there's no impediment or barrier to bringing a case against any individual state based on their emissions. We now have the legal availability there. There's a bunch of fascinating strategic questions about which state should be focused on. If you're thinking about ICJ proceedings, one of the first questions to answer is which countries have made declarations accepting the general jurisdiction of the court, and that is importantly not states like the US, for example, but it does include states like the UK, France, and Germany. So I think there are a lot of interesting questions for climate lawyers thinking about developing these cases. But yeah, I'm not sure if you had anything else to add on that one, Nicola.
Yes, well, no, I understand the question, which is very relevant indeed. The question is whether if one state on its own is not responsible for emissions that are so important as to cause climate change on their own, but only in combination with the emissions of other states, whether that single state can then be held individually liable. I think that is the question. And the answer to that is that emissions, as the court emphasizes, in and out for themselves are not illegal. So there is no prohibition on emissions. The question is what a state can be held responsible for is a lack of due diligence, meaning that it acts in a manner which is capable of causing harm to other states and where it is not diligent enough. Now, being responsible for emissions and emitting while knowing that one's own emissions in combination with those of the others will cause lethal harm is a lack of due diligence.
Mm-hmm.
My answer is not very clear, but I think that is the point. So
Great.
yes, you can be held responsible for having added the straw that broke the camel's back.
Yes, agreed.
Yes.
Wonderful. Thanks, Nicola. Okay, I'll throw the second one over to you, Jen. So this is a question from Sebastian Luengo, who's at IGSD, and he's asking, how could states be compelled to enforce the AO? He says, for instance, the Inter-American Court has developed the doctrine of conventionality control, under which states in the Americas are compelled to comply even with the AOs, which I would probably slightly nuance that statement. But yeah, Jen, how can this be enforced?
Well, I mean, as we know, this is an authoritative determination of states' international obligations, but enforcement of international law is always difficult, and it's very dependent on a country-specific context in each domestic context as to how that might be enforced. As an Australian lawyer, we've just lost the Australian climate case, which was seeking to hold the Australian government accountable for under tort legislation, at least have a duty of care in respect of it. And even though the court found that our government had failed to set appropriate climate targets, that it didn't matter that we weren't able to hold them accountable. So I think it really, one of the things that the Pacific Island states were talking about in the past few days is in terms of having independent climate agencies at home with enforceable, with legislation would, at least in the Australian context, for example, or in the UK, more stringent legislation and oversight over targets. And one of the big things I think for small island states too is the burden on them to be able to hold other states accountable to their NDCs, which is the level of capacity, knowledge, and scientific knowledge required in order to be able to hold other states accountable. So there's an internal aspect of, I think, regulation of states in determining their own NDCs and the accountability at the domestic level for that, and how whether individuals or groups domestically can hold governments to account to their targets. But there's also a much bigger question for small island states about how they can develop the capacity to hold other states, even to understand the science around it. So the cost to small island states about in terms of developing the scientific base to hold states accountable, even understanding the impact on their own countries, let alone the climate targets, is really huge. And the amount of money involved in this kind of practical in the sort of the practical aspects of this is massive, and none of that comes through in the AO. This is very much the lived experience of small Pacific Island states.
Yeah, it's a great point, Jen. I think one of the requirements of this decision, when they're talking about those elements for attribution and causation that need to be proven, is a high level of factual substantiation and scientific rigor behind any future interstate case, right? A state will need to show and clearly document climate-related impacts that they are suffering, which if you think about it at a state level scale, even a small island nation, that's a huge amount of expert evidence, funding, which is required for all of that, let alone all of the time and resources that go to the legal work. So I think that people often sort of expect an immediate sort of response without perhaps thinking about these, as you say, some of the practical barriers to building the types of litigation that we hope to see in the future.
I think sorry, just to add one last point, I think one of the things we ought to be talking about is access to that science, because we know certain governments have it and certain governments don't. And for example, even the cost of the modelling that was presented by Marshall Islands is in the millions and millions of dollars, with data collected over decades to be able to do that kind of modelling. And many of these countries don't have the capacity and the resources to do that. So there's very practical, before we even get to actual enforcement and regulation to implement that decision in domestic and regional contexts, is the practical aspect of how states can even have the knowledge base they need to be able to enforce it.
Yep, completely agreed. All right, so we've got a few more questions here. One is about the jurisdiction of the court and its ability to deal with litigation in relation to loss and damage. Nicola, would you like to pick that up, or I can deal with it?
Well, perhaps I can give a few elements. Obviously, the limited jurisdiction of the ICJ is a problem not only for climate change, it is a general issue, and it could be avoided, or at least it would be far less an obstacle if each state could be held liable for the overall loss suffered by a victim, as is the case in some liability systems where you have a joint enterprise. Each of the co-authors can be held responsible for the entire damage. That would greatly facilitate, obviously, actions in damages under the existing ICJ system. That is not the case, so one has to pick a state accepting the jurisdiction of the ICJ. That's basically it. But there are, of course, other tribunals, domestic courts, human rights courts, who could also work creatively with the opinion and bring further means of redress, I think.
Great, thanks, Nicola. And I think I'll just add there that just on sort of terminology, often people think that loss and damage is a term that refers to all of the costs associated with climate change, but it's actually only referring to the costs of the impacts that can't be adapted to. And so you've got the whole universe of harm, which could and should be captured by future cases, using the whole, as the court says, panoply of the different reparations options available to the court. So it's more than just loss and damage, even though that has become the rallying cry and the focus of negotiations for developing states in the COP process. Okay, so there's another question here about maybe touching on the case you mentioned, the Torres Strait case, Jen. The question is, do you think national courts have the capacity to determine reparations and compensation in complex climate disputes? So I guess this is a question about the types of climate litigation that we've seen in domestic courts, and maybe a question about what this could mean for future domestic climate litigation.
Well, obviously, I mean, and Harj, you can speak to this too. Obviously, domestic courts are limited in their jurisdiction in terms of seeking. It's not like you can seek reparations from a foreign state in a domestic court. So we're looking at national obligations to citizens in respect of climate change. And this is such a country-specific context question that it's difficult to speak to it in any broader terms than that, I think. In the Australian context, we just have such limited mechanisms available and rights and remedies available. And I think what the ICJ decision makes clear is that Australia ought to be implementing enforceable remedies for citizens to hold government to accountable for the human rights violations that we're seeing. And I think the Torres Strait Island decision is an excellent example of the limitations of the law. If we look at that outcome, for example, the judge basically was begging Parliament to change the law and to do more, and limiting and acknowledging the limit of his judicial role, acknowledging the effect of climate change, the fact the government was doing enough about it, but that he didn't have the power to grant remedy under the current state of Australian law. So I think it's just it's such a specific context. I don't know if you want to add, it's such a jurisdiction specific question.
Yeah, certainly. I mean, so what I'll say at a global level, and I think you've already touched on this, Jen, is that this case will hugely enhance, I think, both the number and efficacy of climate cases at the international, regional, and domestic levels. So you've got different legal systems that treat international law differently. Some, like the US, are incredibly skeptical of international precedents from courts like the ICJ. I don't anticipate a lot of direct pickup in terms of the jurisprudence influencing climate litigation in the US, but that's a very robust and well-developed ecosystem of cases already. I think you'll see most of the influence will be certainly in Europe, human rights-based climate litigation, taking the strong findings from the court on this basis, in Latin America, Africa, and Asia Pacific as well. So it's very helpful for human rights-based and public law challenges, but also importantly for corporations as well. So corporate climate liability and litigation, which has been growing a lot in recent years. There is a question about that, so maybe I'll come back to that topic and address another one first and hand it over to Nicolas, which is this question about how the ICJ has interacted with the Inter-American Court of Human Rights advisory opinion, which came out only a few weeks ago. So the question is, how did those opinions interact? Were they generally consistent with one another, or were there any significant disagreements? So Jen or Nicolas, I'm not sure if you have thoughts on that question.
Jen, please.
I'm actually happy to let you have a go at that one, Harj.
Okay, sure. I'll take it. So
don't rule yourself out as chair.
So yes, they're generally consistent in this, to the extent that the ICJ was not nearly as expansive, obviously, as the Inter-American Court. The Inter-American Court is famed for being the most progressive court in the world. The opinion was 240 pages, just looking at human rights law, and they have very progressive jurisprudence. So the way I like to think of it is that the ICJ made key findings that Jen's already spoken about in terms of the right to a healthy environment and a range of other climate, human rights related findings. But they didn't repudiate or close off development of the law in the vein of the Inter-American Court proceedings. So they are consistent in that they aren't contradictory, even if the ICJ is not going as far as the Inter-American Court in terms of repeating and affirming all of their findings. Part of that, I think, is practical. These decisions came out very close to one another, so that you didn't have, as you have with ITLOS, for example, which came out last year, a long lead in and an ability then for the judges to refer to that case in terms of just drafting their opinion. But I think it also just speaks to a different character and profile of the courts. The ICJ is not primarily a human rights court. It spoke about human rights here because it was relevant, but they didn't go as far as the Inter-American Court, I think, for fairly clear and obvious reasons. And if you think about, zooming out and thinking out what that means for the future of human rights-based climate litigation, I think that's a good outcome, because you can have more progressive courts like the Inter-American Court sort of pushing the envelope, while the Inter-American Court the ICJ has not really halted any of that progress. Okay, final question about corporate responsibility. So how does this decision shed any light on the responsibilities of companies for climate change? Currently, the lack of clear guidance on this creates all the wrong incentives for companies. And as a result, many progressive investors are keen for the rules to be clarified. Nicolas, Jen, very happy for you to pick this one up.
Well, perhaps just one word to start. The ICJ case is intrinsically about the obligations of states. So it does cover the obligations of states with respect to corporations under their jurisdiction. And in that respect, the court does find that under general international law, states are obliged to make sure that corporations under their jurisdiction do not cause harm to the climate system or otherwise to the environment. So that is the approach of the ICJ, which is its very nature. So it does not cannot directly make findings on corporate responsibility, but nevertheless, all what that it says can be of potential relevance indirectly.
Just to add to that, the court does specifically reference private non-state actors in its findings and the obligations of state to regulate. But I think it's also interesting how this decision may well be used in the investment tribunal context when you've got disputes between corporate foreign investors and states on, for example, regulatory issues. There was concern raised by a number of states, and Judge Cleveland sets this out in her separate opinion around the role that this decision might play in investment arbitration and the chilling effect that states raised around the ability to regulate to protect, well, in line with their climate change obligations, and how that might affect or result in claims from foreign investors. So I think that is quite an exciting development, and I think we'll see play out in claims. But of course, as Nicolas said, this is an international law decision about the obligations of states, not about private actors. But I think we'll see these standards filter through into different kinds of litigation. Harj, I don't know if you wanted to say something more about that.
Yeah, certainly. Yeah, I was going to speak about it. So I think you both covered off some of the main points. I think that there's the direct legal implications for it in terms of, I think, informing the types of standards of, if you think about directors' duties, making those sorts of arguments in that context. I think this case will be cited there. But I see it mostly in terms of pressure, either legal pressure or advocacy pressure on governments to do more when it comes to regulating the conduct of corporations. At the moment, even though you had a similar finding, not specifically in the fossil fuel context, but about the responsibility of states to regulate non-state actors within their jurisdictional control. You had that from the Inter-American Court of Human Rights from its 2017 environment focused opinion. But now we have, alongside the court specifically calling out fossil fuel production, supply, licensing, and subsidies, that puts the fossil fuel industry in particular in the crosshairs. And I think there's a very strong basis, which I know campaigners are already focusing on, to pressure government to do more to regulate high emitting industries, which is, fossil fuel industry is kind of chief amongst them, to rapidly reduce their emissions. So I think it's a very important finding when it comes to corporate liability, both as a substantive area of law, but as a site of policy advocacy as well. Do you want to come in on that, Jen?
I just want to add one last thing. What I hope this decision will give those governments the political cover they need to do what they need to do. So I think there are governments who are willing to do more and feel this pressure, and this decision, I hope, will give them the political cover they need to do better, and the justification for these kinds of regulatory interventions.
Agreed, and that's certainly the hope. And I think as we all think about the run up to COP in the next few months, it'll be a really interesting time as countries are releasing their NDCs in a completely changed legal context to what they were dealing with about 6 months ago. So I think it's a fascinating time to be in the space. Okay, well, thank you so much, Jen and Nicolas, and thank you everyone for tuning in to today's session. I think it's been a remarkable week and a nice run into the summer break for those of us who are hopefully looking at a holiday soon. So again, thank you all for joining, and thank you again, Nicolas and Jen, for today.
Thank you.
Thanks,
everyone.
Harj.
Goodbye.
Cheers.
Goodbye,
Bye-bye.
Harj. Bye, Jen. Goodbye, all.
Bye. Bye.